Hi, everyone. Thank you for joining us today. Um, my name is Brianna. I'm with We Act for Environmental Justice. And today we are so excited that you are here for this webinar where we will be discussing a very important piece of environmental justice legislation, the Environmental Justice Citing Law. If you are unfamiliar, the Environmental Justice Citing Law, aka the Cumulative Impacts Law, is important to protect disadvantaged communities according to the state definition, or as we like to call them, environmental justice communities in New York State, from disproportionate pollution burdens in New York State. And today we are hosting this webinar in conjunction with lots of our partners who have been um, amazing advocates on the cumulative impacts and EJ citing law to discuss phase one of the environmental justice citing law regulations. We are currently in a regulations and rulemaking process with DEC. And so I will pass it over to Drew to kick us off on discussing a little bit more background of particularly what is SEEKR, also known as the State Environmental Quality Review.
Great. Thank you very much. I think perfect. Yeah, that's the right slide. So I have 5 minutes to talk about the seeker process. So hang on to your hats, bear with me. We're going to go pretty quick, but I think it's important to dip your toes into the seeker process before we talk about what DEC's regulations are going to do. So, the secret process, or the New York State Environmental Quality Review Act, requires government agencies to consider environmental impacts alongside social and economic factors when making a decision about projects that they either approve, fund, or directly undertake. So, Seeker's whole purpose is to balance environmental concerns with other considerations when making decisions about these projects. So if an action is subject to seeker, it's going to be classified as a type 2, type 1, or unlisted action. So your type 2 actions, they've been determined that they're not going to have a significant environmental impact. They don't require lead agencies to go through the seeker process or render a determination of significance. And so these types of projects include things like granting an area variance for single family or two family homes. Our type 1 actions are more likely to have a significant adverse impact on the environment, and they may require preparation of a draft environmental impact statement. If an action is a type 1 project, an applicant must prepare a full environmental assessment form. So a type 1 project might include a project or action that involves the physical alteration of 10 acres. Now, if an action is not listed as a type 1 or type 2, it's creatively referred to as an unlisted action. And an unlisted action, an applicant can prepare either a full environmental assessment form or a short environmental assessment form. And I will say most actions are unlisted. They're not going to be specifically on that type 1 or type 2 list, which are in the regulations. Those projects are identified. And if they're not, again, they're these unlisted category. So an environmental assessment form is a standardized document prepared by DEC, which is used to assess the potential environmental impacts of a proposed project. The EAF is going to help the reviewing agency identify potential impacts that a project might have and determine if those potential impacts are significant enough to warrant a more thorough analysis, which would be done through an environmental impact assessment. The EAF's typically completed in parts, and so the applicant typically does part one, which provides information about the project. And then the reviewing agency is going to analyze potential impacts and determine significance in parts two and three. To make a determination of significance, the lead agency is going to consider what's in the environmental assessment form, and they'll also consider other information that's provided by the applicant, provided by other agencies, provided from public input. And if the lead agency determines that the proposed action may have a significant adverse impact on the environment, the agency is going to issue a positive declaration and require the applicant to prepare a draft environmental impact statement. All right, next slide. So there's a lot that goes into preparing a draft EIS, and it often takes a long time. But the process starts with scoping. So this is a process by which the issues to be addressed in the draft environmental impact statement, or EIS, are identified. And the public has an opportunity to comment on that scoping. The purpose is to focus the EIS on potentially significant adverse impacts and to eliminate considerations of those impacts that are irrelevant or not significant. The draft environmental impact statement outlines the potential environmental impacts of a proposed project, and it serves as a platform for public review and comment. So the public really gets involved and they're allowed to evaluate the project's potential environmental impacts and suggest ways that the developer could avoid or mitigate adverse impacts. Once the draft environmental impact statement is accepted as complete by the lead agency, a public comment period is going to be open, and that period is for 30 days. Now, the lead agencies are required to accept written public comments, but they are not required to hold a public hearing. The hearing is optional. Now, once the public comment period closes, the final EIS must be prepared. And this document is going to include any necessary revisions or supplements or extra information and the lead agency's responses to comments. So all those public comments that were submitted, they will have responses in that final environmental impact statement. Now, once the final EIS is deemed complete, the lead agency has to issue a seeker finding statement. Now, a finding statement considers the relevant environmental impacts presented in the EIS and balances them with social and economic and other essential considerations. Now, a positive finding statement means that the project can be approved and demonstrates that the action is one that avoids or minimizes adverse environmental impacts to the maximum extent practical. So, not completely, but to the maximum extent. A negative finding statement means that the project will not be approved. Now that's the seeker process. Let's talk about the environmental justice citing law and what it does to this process. So I'm going to hand it off here.
Great, thank you. So really what we've been doing so far, we've just given you some context as to what the seeker process is. And that's really important in order for us to understand what is this rulemaking process that's going on right now. What is the environmental justice citing law? So in 2023, legislation that was carried by Senator Stuart Cousins and Assemblymember Pretlow was signed into law, requiring the consideration of cumulative impacts in the seeker process. And what this means is that when a lead agency or the DEC are reviewing actions that are taking under seeker, they have to evaluate whether an action may cause or increase the disproportionate pollution burden that disadvantaged communities may receive. As part of this, why this is so important is that the law is incredibly crucial in protecting the health and well-being of New Yorkers who are in these communities and have for far too long experienced the disproportionate impact of the permitting process that's led to more and more polluting within their homes. So as an example of this, if a new wastewater treatment facility was being built in a disadvantaged community, we'd have to consider what the existing impacts of those pollutants are that already exist. And this now must be part of the decision-making process in order to mitigate any further harm that's happening in these communities already too much. So things that you might consider is whether or not the amount of trucks that are going through a disadvantaged community daily and impacting noise pollution, but also impacting the air quality that's happening there. And on our next slide, we're looking at what are the different paths to pollution. So this is just a prime example of some of the different ways a disadvantaged community could be experiencing different pollution within their communities. So we can see air emissions from different polluting sources, the stormwater runoff that's going into the water that's within their community, wastewater treatment plants, contaminants that may be existing within the soil and running off into the water, transportation, whether it be from trucks, from passing vessels, and also then the existing microplastics that can be in our water from additional pollution. So then when we're thinking about the Cumulative Impacts Law that's led us to where we are right now, which is the rulemaking process, which has been cited the Environmental Justice Citing Law. So what this means is the DEC has begun the rulemaking process to ensure that they are complying, and anyone who is submitting applications as part of the permitting process are complying with this new environmental justice citing law. So some of these changes that we're seeing include changes to the seeker regulations themselves, changes to the environmental assessment forms, which include additional questions focused on disadvantaged communities. And these are forms that are part of the seeker process. And additional draft materials to help lead agencies in evaluating the impacts to disadvantaged communities. Some of these materials include a draft seeker workbook guidance, as well as the disadvantaged community assessment tool, which we'll also be going to a little bit more detail. And these are all different resources and documents that we are reviewing now, and we're making sure that when the DEC wants to use them in the future, that they're aligned in the best way possible to protect the interests of disadvantaged communities. And so I'll hand this over to Michael now.
Thank you, Neef. What is a disadvantaged community? And is something I want to talk a little bit about. And what does it really mean to be one? And how has it been designated that way? It really determines communities that have been sharing burdens of negative public health effects, environmental pollution, impacts on climate change, and possesses in certain socioeconomic criteria and comprise high concentrations of low, moderate income households. The environmental burdens and climate change risk, population characteristics, and health vulnerabilities at a community level is the concentration that the Climate Leadership and Community Protection Act, the CLCPA, we call it the Climate Act, really designated through the Climate Leadership, the Climate Justice Working Group designated that criteria, that these four levels of designation or determinations is what determines if a community is a disadvantaged community. We find that there's many other indicators as well. And this criteria is important because this is what we're looking at with the climate. Our new climate community environmental impact law will really give more heavy credence to these types of communities. Next slide. This is a map of the disadvantage assessment tool showing the actual accumulation of the culmination of different types of communities around the state that are categorized as disadvantaged communities. As you see, the map is pretty well littered. We don't see a really high location, a real magnifying glass into New York City, but across the state, we have plenty of disadvantaged communities. Next slide. I just want to talk really succinctly about, most of my time is going to be talking about a case study of how SECRA failed to protect a community that's considered a disadvantaged community. In the South Bronx, where we advocate for environmental and social justice, one project in particular was Fresh Direct, which was a relocation of a heavy diesel truck intensive operation from Long Island City, Queens to the Bronx, was to be placed in a community that's 90% people of color. And in the community, it's also recognized as a disadvantaged community because of its health burdens. Where 1 in 5 of our children have asthma, where we have some of the highest asthma hospitalization rates in the city. It's 17 times that of other New York City communities, but 8 times the national average. Where we have polluting facilities like you see in this slide, from waste transfer stations to peaker plants, where we have 4 placed on our peninsula. But you see the high concentration of asthma hospitalizations directly linked to the placement of these facilities because they've been permitted to be here. And most often, these facilities were placed here without full environmental impact statements. Next slide. So how it failed us, right? With this project in the Fresh Direct, it was proposed in 2012 as a done deal by our governor, mayor, then Governor Andrew Cuomo, Mayor Mayor Bloomberg, and also our borough president, Ruben Diaz Jr., hailing it as a done deal, proposing $150 million taxpayer subsidy to relocate this entity from Long Island City, Queens, to the South Bronx, even though the project was proposing to bring 1,000 diesel truck trips to this community, which was considered then as Asthma Alley and still is, which I talked about the high percentage of asthma hospitalizations. We knew this would exacerbate that. There was no cumulative burden analysis done and conducted. It was related to the highest rates of asthma and how that situation was ignored. Our criteria for being the siting place for more facilities like this could contribute to our poor health outcomes was not something considered. They relied on an environmental impact statement that was for other projects that was 19 years old in 2012. And, regardless of the population of our community had changed, other factors such as science had changed in terms of recognition of PM 2.5 in 2012 was not in 2000 and in 1991 when this initial environmental impact statement was created for other projects, it was not recognized. Here in 2012, we had so much more data around the impacts of traffic and pollutants on communities like ours. So the overwhelming, opposition from the community meant nothing. We found this out 4 days before the first public hearing in 2012, after it was announced as a done deal and a great thing for the community as an economic driver and a job creator. But what was not looked at was the traffic was going to impose on our community and the congestion and the pollution that was going to add to our existing burdens. So the community filed a lawsuit against the New York City Economic Development Corporation Association or Administration against the state, which was also going to leverage from taxpayer subsidies this project, and to the leaseholder, who was going to now lease this property or this parcel of land on this waterfront site that was publicly owned to this developer and sited on a location that was documented to be a Native American burial ground. None of that meant anything to the courts. They deferred to the lead agency, the Industrial Development Agency, and their designation that there would be no adverse impacts on this community. And the relocation, it was determined that there would be no there will be no significant impact on us. But post the relocations of the plant, and once we lost in court, we did our own environmental analysis. We partnered with the Columbia Mailman School of Public Health, where we actually did our own air quality monitoring and traffic counting. And we determined by placing air quality monitors in key locations where fresh direct would traverse through our community, that there would be an increase in black carbon, that there would be an impact in traffic and increase that traffic and creating more and more unhealthier outcomes with poor air quality. And this has been the example of what's been happening across the South Bronx for decades. From Robert Moses creating the Cross-Bronx Expressway, to one project for the peaker plants being placed there. Most of these projects were placed, like Fresh Direct, on assessments. And unfortunately, Fresh Direct's assessment was based off of that 19-year-old environmental impact statement. And I'll pass it on.
Thanks, Michael. And I think that case study is really important to remember as we think about what DC is trying to do with secret regs to comply with the environmental justice citing law. And I think a positive to that effect is that, it's clear that DC is really thinking about how to comply with the environmental justice citing law and how they can best set up the secret regulations to do that. The citing law, as previously mentioned, has this component that is about seeker, which will apply to all lead agencies in the state, local and state agencies, and a permitting section that will apply just to DC. So, it is important that DC is taking into account the fact that these different lead agencies are all going to come into this different expertise and different expectations. And so how do you set up a system to get them all to comply? I think it's also important to mention that DC has taken public participation on the secret regulations very seriously. They've taken over 3 months for public comments, which is a long time for agency regulations. Some of them have 30 days, and this is a much more robust comment period. And we'll go over when these hearings are and at the end, but DEC is also hosting 4 public hearings, 2 are virtual, 2 are in person. They're at different times of the day. The in-person ones are in different regions of the state. And so again, really attempting as best they can to put in a public participation process that is open and allows for different groups and a variety of communities to comment, both in writing and in person. And we'll talk about some of the problems with some of the tools that DEC has created, but they are, I think, based on all of these tools that they're creating as supporting documentation for the regulation change and the changes to the environmental assessment form, attempting to make it difficult for lead agencies to just continue on with the status quo. It really does feel like DEC is trying to make an effort to standardize this process so that lead agencies have to consider the effects of projects on disadvantaged communities and the population vulnerabilities and pollution burdens that made these communities DACs in the first place. And for lead agencies not just to be able to say, kind of rush through this process and be able to do exactly what they would have done anyway with no further explanation. Next slide. So despite DC's good intentions, we do have some issues with these secret regulations. And I think some of kind of the overarching concerns that our groups have is that the regulations don't make it clear how cumulative impacts would be reduced, which was one of the intentions of the law in the first place. We think that DC needs to make it more clear how multiple effects of environmental health and social stressors harm DACs, and also be able for agencies when they're thinking about projects to think about intersecting burdens such as pollution and lack of healthcare, and how do those things go together. It's not clear from either the regulations or any of the supporting documentation how lead agencies are supposed to think about the actual cumulative impact of different pollution burdens and different community stressors, and how those things work together rather than simply, well, there's more pollution. So that's something we think DEC needs to make clearer to lead agencies and provide them with tools to do. A second issue is strengthening the definition of disproportionate burdens and what it means for a DAC to be disproportionately burdened. So the interim guidance that DEC gave, it's one of the supporting documents that go with the regulations, requires kind of the burdens be significantly greater than other communities in order for the burden to be disproportionate, which really feels like a narrowing of the scope of the law. The law doesn't kind of separate out in that way. And, because of the way DACs are defined and the intentions of this law, we believe that DACs should be presumed to be vulnerable to new burdens unless proven otherwise, and presumed to be already disproportionately burdened. And we think DEC should make that clear again in its regulations and guidance to lead agencies, so that when projects are being proposed, the lead agency starts at a position of disadvantaged communities have disproportionate pollution burdens, they're vulnerable to new pollution burdens, and then the project impacts are taken into account from there. Next slide, and I will hand it over to my colleague Nikki.
Thanks, Marissa. So some other issues that we're seeing with the secret regs include having tiered DAC classifications, and that kind of relates to what Marissa was last saying, is that DEC doesn't seem to understand that DACs already have a disproportionate impact. And they created a so-called DAC assessment tool, which then breaks down DACs into 2 different groups, blue and orange, with one group being relatively higher and the other relatively lower in terms of aggregate burden scores. But we think that all DACs deserve protection under the law. And then some issues with the mitigation priorities that DEC lists or doesn't list. We think that lead agencies should do the following three in this order. Try to prioritize avoiding harm to DACs, then minimizing impacts, and then finally considering net benefits as a last resort. And then we also think that in considering mitigation and alternatives, DEC and other lead agencies should explore alternative siting outside of DACs or sensitive areas within the DAC. Great. And this is just a picture of the DAC assessment tool, and you see the areas broken down into blue and orange, and then also indigenous territories in yellow. Some points we think that DEC can make to improve public participation and transparency, both in this current period and in the secret process, are to improve accessibility, including by providing plain language summaries and multilingual materials, to improve community engagement by creating a public database for project documents with translated materials and meeting recordings, and to disseminate updates via mail, email, and local media. And then we think DEC can improve transparency by mandating hybrid public hearings during scoping, mitigation, evaluation, and draft EIS stages. And then we created a template for writing public comments, and you can also use what we wrote as a template for providing verbal comments at the upcoming meetings, which we'll go over soon. But I think Brianna is going to, yeah, Neve shared our template, which we will send out in PDF form after the meeting. Basically, we lay out what we just covered in the presentation, and encourage you all to add information about how you and the communities you represent are affected, and why this is so important to get right.
Thanks, Nikki. Thanks, Neve. So I'm going to walk us through what are some next steps. As Nikki shared, we have developed some template outline comments for you all to take back and use as much or as little as you wish, particularly telling your own story, the own story from your community. What are the multiple polluting sources? And I think all of that information is also incredibly important to share, not only written, but also orally with the public hearings that are upcoming in the next week or so with DEC. So as we mentioned, there are two virtual hearings that are upcoming. Um, they are on Wednesday, April 23rd, 2 p.m. to 2 p.m. and 6 p.m. And then also on Thursday, April 24th at 6 p.m. in the LIC Queens area. And then there is one Wednesday, April 30th, 6 p.m. in Buffalo. So there is a downstate, upstate option, and a virtual option to attend. Yes, if you're looking to access the template, we will be emailing that to you as a PDF after the webinar. Of course, with the template, that is up to you to submit your own letter to DEC. The ways you could be doing so to submit written comments is by emailing that email that they've provided with the subject line comments and pros part 617 in the subject line of your email. You could also send a letter via mail to that mailing address to the DEC Division of Permit. and the comments are due May 7th for this first phase on seeker. What's to come is right now we are in phase one, changes to the seeker process, which, as laid out by Drew, would assess existing burdens to DAC, and is the process in determining whether facilities will need to prepare an environmental impact statement. Phase two will be on the existing burden report, and I think it's safe to assume that phase two will begin after the close of phase one at May 7th. Phase two will look at the scope of what DEC believes should be part of the burden report and what should go into that report for consideration. So, for instance, as in Michael's case study, we saw that in the South Bronx, there was no existing consideration. There was no consideration of the existing burdens that were taking place in the South Bronx before the um, approved project for Fresh Direct went in, and that is what we want to see is that consideration for existing burdens and pollution burdens in these communities before permitting approvals. Then phase three will look particularly at the permitting regulations, which we can also assume will come in sequential order following phase two. So when the close of phase two happens, then we'll see phase three permitting regulations released, which will have to do primarily with the Uniform Procedures Act, where DEC will be looking at when to consider the existing burden reports, under what conditions is permits denied, when existing report will be required, what facilities are essential to the community, what does that mean? And we'll be needing a lot of community input on this phase. All these phases are important, but we will be seeing a lot more of the permitting regulations in phase three. Next slide, please. So in addition to that, I think what we are seeing is, yes, options for community engagement provided by EDEC. However, I think that much more public comment is necessary, much more public engagement is necessary if we want to see robust implementation of the Cumulative Impacts Law, considering all the variations of diverse communities across New York State and what are the pollution burdens they are experiencing. So telling stories, telling DEC what you want to see come of the law and your ideal outcome, I think is important in each phase. And so what we have also created is an easier, if you're an organization, I think we'd recommend submitting your own letter using the template that we will be sending you via PDF. If you are a community organization with members or a community-based organization with individuals, or if you represent a district and you want to share this comment period with your neighbors and friends, we've created a simple couple clicks tool in this action network .org link that you see there that we'll also be sharing after the presentation, that has a lot of the content of the template, but in a easier format than taking it, downloading it, writing your own letter, uploading it to DEC and sending it as a PDF. So that will make it easier for folks with directions to also submit their own comments. And lastly, but not least, more community engagement. We Act for Environmental Justice and some of our partners are continuing to engage the public with all phases of this rulemaking process. If your organization, district, community would like to co-host a presentation with us in any part of New York State, in person or virtually, do please fill out our intake form, which will just require your name, part of the state you're from, and ways to get in contact with you. so that we can continue to do presentations like these, but in different formats that are maybe more digestible to different audiences, and help talk you through how to submit comments and use some of the tools that we have available. Here is everyone's contact information for the folks that have been most heavily involved in developing this presentation and in developing our comments for submission. So if you are looking to contact anyone from the organizations that are represented today, here is a good list to use and reference. Some more additional resources are here, and if you would like to receive a copy of the slides, the public comment template, all the other resources that we have listed here in the presentation, please email Neve, and her email is right there at the very top. If you want to take a second to write that down, you can leave this slide up for a second as well, Neve. And we would also like to, yeah, so that's the way to get the information in Neve. You can also drop your email in the chat if you would like us to follow up with you that way. It's just a couple different options. Okay, let's go to the next slide.
And I think that's it, Brianna. I think we're on to our question and answers now.
Okay, great. So I think we're going to be opening up everyone to Q&A, which myself and or Neve will be facilitating. I see a couple of questions in the chat, which I have not a chance to read yet, but would anyone be wanting to come off mute and or raise their hand to kick us off with their first question if you have a question? We gave a lot of information in this presentation, so no question is silly or should not be heard. Okay, I see a question from Dara.
Hi, yeah, thanks so much. This was super helpful. I have two questions, but I'll start with one and then I'll wait and see if other people have questions before I ask my second one. On the tiering classifications, I'm wondering if you guys have any insight on what, like in a practical sense, the tiering means. Like how would orange or blue tiers be treated differently from each other?
Thank you. I think that would be best answered by Marissa or Nikki.
Yeah, I can take that question. So according to DEC's guidance documents, the way they intend the tiering to work is for identification purposes of DACs when filling out the environmental assessment form. So if you look at DEC's proposed changes to the environmental assessment forms with the short and the full one, you'll see that there's a question that asks about whether the DAC is like basically a comparatively higher burdened or not, and that would be the orange versus the blue. And then answering that question feeds into the analysis of whether or not there's going to be a significant impact and the lead agency needs to have an EIS prepared. So the idea being if it's in a comparatively higher burden DAC, it is more likely to have a moderate to large impact. If it's in a blue DAC, it's less likely to have it's a moderate to large impact and more likely to have a small impact. So that's how DEC says they would like the tiering to be used and how it should be used is this kind of like identification tool, but that shouldn't ultimately work into the seeker analysis, that you should then still be considering the impacts on the DAC, and it doesn't really go past that initial question. I think a concern that we have is once you've opened the door, it's kind of hard to close it, especially with lead agencies that, are doing some of this work for the first time. that it's going to be difficult for then that agency to say, well, this project's in a blue DAC, but that doesn't mean anything in terms of the impacts. Like, they're probably still going to use the tool to say that, well, this is in a less comparatively lower burden DAC, and therefore, the impacts will be lesser, and we don't need to prepare an EIS, or down the line for the project applicant to say, this is a reason why this project won't have as much of an impact in the existing burden report. So I think we're just generally concerned about that, but it is true that DEC is saying that it is an identification tool and not an analysis tool.
That's helpful. Thank you.
Thanks, Dara. Okay, one question I see in the chat is, are we doing an analysis on the potential impact of the EJ siding law if Senator May's seeker accepting law, and then there's a bill number, the Affordable Housing and Sprawl Prevention Act, is passed? Anyone here part of the presentation familiar with this piece of legislation?
Brianna, I'm not familiar with that piece of legislation specifically, but I think it's important to note that this presentation focused on analyzing cumulative impacts on DACs, but the DEC's proposed regulations also include language to extend the type 2 list, which gets at that point already. So it would be in addition to constructing or expanding single family homes or two-family homes that are already type 2s, the regulations now include multi-family dwellings consisting of a three-family residence, and also constructing a building with 4 or more dwelling units if it meets all these other requirements that are included in the regulations. And that's the goal of expanding the type 2 list to include that type of construction, is to allow for more affordable housing developments and to reduce sprawl. So, if that goes forward, those are type 2 actions, which would not be subject to seeker. So they would not go through this analysis about impacts on disadvantaged communities. So that is important to keep in mind. And so I don't know how that would play into the proposed legislation, but I think that this addition to the type 2 list gets at that point and gets at that concern.
Thank you, Drew. Okay, I see a follow-up question, it seems like from Bridge in the chat, stating, what is the justification DEC might be offering for the new DAC map that we were discussing, the DAC cat tool?
Yeah, so DEC didn't necessarily offer a lot of justification when they looked at the tool. They wanted to create something to help lead agencies assess disproportionality and consider whether a potentially affected DAC has an increased likelihood of experiencing a moderate to large impact based on its existing burdens or vulnerabilities compared to relevant non-DACs. That's what DEC was trying to do. And I think, again, the goal here for DEC was to create some sort of standardization for comparison, so that when a lead agency or a project applicant looked at a DAC and said, well, let's compare this to non-DACs to see about whether project impacts are going to be worse here than anywhere else, they didn't cherry pick, completely unrelated non-DACs that would provide a completely arbitrary baseline. I think the idea from DEC was that this was a tool that would create some kind of standardization. The maps are based on the Climate Justice Working Group's 45 indicators that created DACs, and use the population vulnerability score and the pollution burden score from those indicators to create the maps. That said, there's also, a level of arbitrariness here that is, just what DEC was deciding to do, and they didn't necessarily explain why. So our kind of thought from looking at their methodology in the map is that they were kind of trying to create a 50-50 split between comparatively higher DACs and comparatively lower burden DACs. And what they ended up with was a 54-48-46 split. But like that kind of assumption appears to be baked into their methodology. And it's not clear why they did that. Other than, again, I assume their thinking was that if they said that all DACs are equal, you know, that's something that project applicants and lead agencies would try and get around for DACs that they thought were lower burdened. And by setting a standard, you know, you lessen the subjectivity from those lead agencies.
Thanks, Marissa. If you have more, I think we're going to wrap up questions in a couple of minutes. If anyone have any other questions, please raise your hand, put it in the chat, or come off mute.
Brenda, there was one question in the chat about whether is this only applying to new projects or would it apply to permit renewals for existing projects? And I know we put we had there's some answers in the chat, but just for purposes of this recording, I think it might be good just to discuss those. So I know, I was looking at that question, but from a seeker perspective, and so for seeker purposes, if the project's been issued a negative declaration before the end of the year, it doesn't need to include any analysis of impacts to disadvantaged communities. The seeker process is over for that project. If it received approval, if the lead agency accepted the draft environmental impact statement, they're not mandated to go back and include impacts to disadvantaged communities. It is recommended, though, that if anyone in the public submitted a comment about impacts to disadvantaged community, that comment is addressed in the final environmental impact statement, but that's not mandatory. It's just highly encouraged by DEC. And so all projects going forward right now, if they have a pending, if they're pending seeker review, if they're in the works of doing their draft environmental impact statement, even if the public comment period's over, if that draft environmental impact statement is still in the works, this is critical. This law is effective, even though these regulations are in draft form. These impacts to disadvantaged communities need to be part of the discussion and need to be included. I know, Nick, if you want to go through and answer looking at this from the permitting aspect that we'll see in phase 3, that might be helpful.
Sure. So at the permitting stage, new projects can't be approved if they will cause or contribute to more than a quote de minimis or trivial amount of pollution. And then it differentiates for renewed projects, which can't be approved if they would significantly increase, quote unquote, the existing disproportionate pollution burden on the DAC. And a good question follow-up from that from Courtney Williams was if they're pre-existing, it doesn't matter if they're a major polluter. And we think that will depend on how DEC interprets the statute. But that shouldn't be the case, and that continued pollution is significant. And that's something that we should highlight in the later phases regarding permitting regulations.
And I'll also just add to what Nikki said that determination, significant increase or de minimis, for these projects is going to be based on the existing burden report that project applicants will be required to do if the project creates or causes or contributes more than a de minimis amount of pollution to the DAC. So for permit renewals, even though the standard to deny the permit is higher, the burden report still needs to be prepared if there's a lower standard, and that burden report is, where things like the baseline of pollution from a renewal could be addressed. And so what goes into the existing burden report is going to be phase 2 of the regulations.
Thank you all. I see Anne, hand up. You're on mute, Anne. Anne, if you can unmute.
Yes, okay, yeah. My question relates to affordable housing. Clearly, there's a need for more affordable housing in all communities. The question is that the location of that affordable housing, which tends to be placed within the EJ community rather than located elsewhere. And there are many barriers to that, to locating it elsewhere, usually objections from other neighborhoods. Is there anything in the state regulations that might address uh, attempting to place spread out affordable housing into other areas within a town or a village?
I'm not familiar with any legislation to that effect. For purposes of seeker, I mean, DEC is attempting to remove barriers by expanding the type 2 list to include construction of these multifamily dwellings, which should help move affordable housing construction forward, but they still have to go through, site plan approval processes and be reviewed by the municipality, and there's public comment opportunity during those other aspects of review. But as far as seeker's concerned, it's not encouraging affordable housing developments elsewhere, but it is, as far as the draft regulations are concerned, it's removing some of those barriers to that type of development. But again, I'm not familiar with other legislation that has been passed or is proposed. Again, someone had put in the chat that Sustainable Affordable Housing and Sprawl Prevention Act, which I'm not familiar with, and if that will move forward if DEC adopts these regulations, I think that remains to be seen.
Thank you.
I see in the chat, at what phase will they define essential environmental health or safety of need the disadvantaged community for which there is no reasonable alternative? Nikki had put phase 3 just for purposes of the recording. I believe that is correct, but others feel differently. Please say that. Okay, it seems phase 3. Dara, I know you said you had a second question. If feel free, I think this is going to be our last question.
So if others have other questions, I don't want to be the last one since I've already spoken. Okay. My question is also about the type 2 the inclusion on the type 2 list of multifamily housing. Um I um I understand. So I understand that currently there's already, type 2 already includes single family or two family, and this is just incorporating multifamily to that list. But I just feel concerned about it just seems like an odd time to shunt this into type 2 here, since they can't really explicitly say we're trying to get at affordable housing here, because that's not within the purview of type 2 to say like, oh, it's fine to skip seeker if it's affordable, but not if it's not affordable. So I guess I'm concerned about the place of this change within the context of the EJ siting law, and if this is like really an appropriate time for the state to be trying to do this. And also, like Anne was saying, as much as we need more affordable housing throughout the state, I don't know that the answer for anyone, including the families who would be living in affordable housing, is to shortcut environmental review processes and these new regulations. Especially, yeah, as Anne was noting also, if these structures themselves, which wouldn't necessarily actually be affordable housing, I don't see anything here that's preventing like luxury housing from going in under this type 2 exception. Um, yeah, just who is this really benefiting, and is it really disadvantaged communities? That was a little disjointed. I guess that's what I've been thinking about, and I'm curious about others' reflections on it.
No, I've had the exact same thoughts, and this expansion of type 2 list it doesn't have anything to do with the cumulative impacts law. Like it just kind of seems to be thrown in here. My theory, Dara, is this is not, I have not asked DEC to confirm or deny this theory, but my thought is that there's pressure to build affordable housing. This is DEC's attempt to remove barriers, although you're exactly right. There could be other consequences and fancy condominiums that go up because of this. But I think it's timed right now because of DEC's wetland regulations and that DEC has issued a draft general permit for housing developments. But in order for that general permit to be applicable, it can't be subject to seeker. So if it's subject to seeker, it's not eligible for the general permit. So if DEC adds it to the type 2 list, then they can pursue a draft general permit for that housing development. So that's my thought is that DEC is doing it now to time it with other changes that they've implemented this year. But again, those general permits are still drafts and they haven't been finalized, so I don't know that could change, but that's my theory on why it's happening now, because it doesn't directly relate back to the cumulative impact law. But again, not confirmed by DEC, just trying to, I've had the same questions. That's kind of where my thought process was. So you're not alone.
Great.
I'll,
Thanks,
I'll,
Drew.
I'll also say that, again, not confirmed by the agency in any way. It is generally easier for agencies to make any changes they're going to make to a regulation all at once, as opposed to like making changes related to cumulative impacts now and then other things later, to do it all in one rulemaking and public comment, because these things take time. They require agency, expenditure of people and public hearings and all of this. So I do think, in addition to what Drew said, there is, a sense of if we're going to open up seeker to review right now, we're going to open up, everything. I mean, and you'll notice if you look at the express terms document where they changed the wording of the regulation, there's some stuff to comply with the climate law, the state climate law in there as well. And some, minor changes to language where they changed some section numbers and things like that, and not all of it is directly related to the cumulative impacts and siting law. And again, it just, once you've opened up the regulations for public comment and once you're opening it for revisions, you might as well clean up all of your typos and add in anything else, like again, relating to the climate law that they wanted to add in that all kind of works at this. So I think that answers some of the questions on timing in addition to what Drew said.
Mm-hmm. I guess my question is if any of that is right or if it's worth commenting on. But can continue those conversations. Not right now. Thank you both for your answers.
Thank you all. So we're at 3 o'clock. If you want to receive the recording, copy of slides, templates, please put your email in the chat or email andmore@eny.org. Thank you all for joining us. Again, I'll reiterate that the Cumulative Impacts Law or EJ Citing Law is entirely based on your story, like not entirely based on your stories, but it's important that you tell your community story, important to provide your regional contacts across the state to help DEC create these regulations as the rulemaking continues. So whatever personal edits, personal stories, pollution burdens you want to continue to add in the comment phase, please do show up to um, the community public hearings that are taking place that we've just shared with you all as well, and share it as widely as you can. Thank you all.